The next case on the Southern panel's panel argument for today is Derek Johnston versus Real Party and Interstate of Nevada, case number 83968. Counsel, as we did in the previous case, I'm going to add 2 minutes to each of your arguments and ask you to share with the students who are here with us today your perspective on the facts of the case before we get into your legal arguments. So if you describe the case and what happened in the district court below, then we can proceed to arguments. Ready to go, Mr. Claus?
Yes, sir.
Okay.
May it please the court, my name is Augustus Claus and I am here representing the petitioner, Mr. Derek Johnston. Your Honor, this case, not to be grandiose, represents a battle for the heart and soul, for the integrity, and for the longevity of the Valdez-Jimenez decision. It also presents a bit of a reading test to me. As I look at the NRSs, particularly NRS 178.4851, and I find it to be clear in these circumstances, giving clear guidance. The facts in this case are a little more interesting. Mr. Derek Johnston is ultimately charged by way of criminal complaint in justice court, and he waves up on a negotiation that he ultimately does not enter into in district court. He fails to appear at one hearing. One justice hears the motion to quash the bench warrant and ultimately places him back on electronic supervision. Less than 30 days later, Mr. Johnston is returned to custody by electronic monitoring for putative violations. He stays in custody for 2 months while an evidentiary hearing is put together. Ultimately, the evidentiary hearing is continued twice for the presence of the house arrest personnel. They never end up showing up for the October hearings. Regardless of their non-appearance, the district court, despite the evidence offered by the defense, finds Mr. Johnston in violation, but places him back upon electronic monitoring. A few months after that, in November 13th, he is rearrested by electronic monitoring personnel for probable cause to believe that he's violated the terms of the electronic monitoring again. It takes another 2 months to have the matter heard by the district court. During that time, this emergency writ is filed, and ultimately that's what we're here arguing today. The facts of the case involving Mr. Johnston involve 2 other cases from Justice Court, 20 CR 030809 and 2102116, which, as of me standing before you today, have all been dismissed with prejudice on the dates of May 9th and May 12th, respectively. Currently, the only case in which he is subject to electronic monitoring is the case before you from the district court. When I said that this is a battle for the hearts and minds, for the hearts and soul of the Valdez-Jimenez decision, Your Honor, that's not too far off the truth. The argument here between the parties and what the state has successfully apparently convinced the 8th Judicial District Court is that Valdez-Jimenez, despite its language and its progeny, is a one-off decision. It applies only to the initial arrest detainment. Despite its language to the contrary, that any time someone is arrested and remains in custody, there must be a prompt individualized determination. The state's reading of that language and the 8th Judicial District Court's reading of that language is that it and the principles that Valdez-Jimenez espouses are wholly inapplicable to a pretrial defendant's alleged violations of electronic monitoring program protocols. For that reason, there is a disparity between the justice courts and the district courts in the 8th Judicial District Court. when someone is arrested on electronic monitoring, on purported electronic monitoring protocol violations, let's call it EMP if I can in the future, justices. In justice court, they're almost immediately brought before the justice of the peace. Their attorney is summoned, and there is an argument that is held at that hearing to determine really the severity of the violations and whether or not it justifies holding the person in custody. If there is not an agreement as to the severity, then an evidentiary hearing is scheduled thereafter. And the justice of the peace orders the production of whatever evidence is necessary to effectuate that evidentiary hearing, as happened in this case in cases 20 CR 030809 and 21021016. That did not occur automatically in the district court. The district court's position on the record in the transcript submitted to your honors, justices, is that their only duty is to notify the parties that the client has been returned to custody. They have no duty to set a hearing. And in this case, particularly twice, the petitioner stayed in custody for approximately 2 months while his counsel gathered sufficient evidence to effectively prove the allegations, or at least the most significant allegations of the EMP personnel, to be demonstrably false. In the first case of the violation, he was alleged to have been...
And counsel, to be clear, who bears the burden?
I think, Your Honor, under Valdez-Jimenez, it should be absolutely clear that the state bears the burden. Moreover, Your Honor, that's where the rub comes. There are NRSs on point that can be found. NRS 178.4851, NRS 178.499, NRS 178.487. All of these NRSs must be read harmoniously, but they make it clear that even under NRS 178.499, that there is a burden to give an opportunity to be heard, and either the district court must file a motion on its own to remand the individual or increase his bail, or the state must file a motion to remand the individual. The most troubling aspect of this case can be found in the state's answer. The state indicates that when I challenged the probable cause to arrest Mr. Derek Johnston, they say, no, look at NRS 178.481.4851, subsection 9, and there you find the authorization for a peace officer to arrest an individual who's believed to be in violation of their pretrial release conditions. But the state, similarly, in their briefing, presents to the court that NRS 178.4851, subsection 7, simply doesn't exist. When it says to the court, there is no provision for intermediary sanctions. To be candid with the court, that is utterly false. And NRS 178.4851, subsection 7, provides 3 possibilities. 1, holding the individual in contempt pursuant to NRS 22.010, increasing their bail pursuant to NRS 178.499, or holding the person without bail. Now, the last section is the least thought of, as I conveyed to the court in my briefing. It was added in the last legislative session, and there was no discussion about its interjection at all. Indeed, the legislature seemed to be concerned with other interjections that were attempting to be put in, and ultimately...
I'm sorry, don't all of those options presuppose that somebody is going to get brought before a magistrate in the district court, within a reasonable time of being put into custody?
They do.
That's what's missing.
They absolutely do, but the problem is the NRS doesn't say that. For there, we must hearken back to Valdez-Jimenez. And Valdez-Jimenez says there must be a prompt, individualized determination. My reading of Valdez-Jimenez and the progeny upon which it's based on is that it is not strictly limited to the initial appearance. As was said by the United States Supreme Court, you can have depredations of liberty that follow the arrest and the initial determination just as well as you can at the arrest itself.
But
and
you would acknowledge, though, that the import of Valdez-Jimenez about people being arrested and alleged criminal conduct having occurred is that we want a judge to review that within a very short period of time and decide whether they should be in custody, and if not, what's the least restrictive means to ensure their community safety and their return to court, correct?
I would agree that Valdez-Jimenez gives many imports. Those are two of them.
Okay. But with that in mind, when somebody has been released on electronic monitoring, that determination has been made that that's the least restrictive means. So when they come back to court on a remand, the question is now whether you have violated a court order in terms of complying with your release conditions.
Precisely.
Not about whether you committed a crime.
Actually, Your Honor, if I may respectfully disagree with you, you are both precisely correct and slightly incorrect, because the NRS embraces both of those. That is why it gives three options. And you look back to Valdez-Jimenez to inform you as to which option is appropriate. Under subsection 7A of 178.4851, it says be held in contempt. Under subsection B, it says increase the bail pursuant to 178.499. The prerequisite there is a showing of good cause. And you still have to address the bail in accordance with the other bail factors. You cannot simply ignore them. Valdez-Jimenez says that there are really only two factors that can be considered by the court when setting a bail amount or when setting bail conditions. One is the risk of flight, and two is the dangerousness to the community. All the other factors that we look at, the length of residence in the community, the criminal background, the crimes themselves, they feed into those two factors. And ultimately, the court makes a decision that under Valdez-Jimenez, if there is any bail or conditions imposed beyond what is necessary with those two conditions, it is deemed by law to be excessive.
So you mentioned the court makes a decision and you mentioned good cause. In this case, your client had waived his preliminary hearing, so he was in district court.
Yes, Your Honor.
So we're speaking of district court, and you would agree, I'm sure, the district court is in the best position to make that decision and assess whether there's good cause and fashion whatever remedy should be fashioned for a challenge to the house arrest remand.
When they have the proper legal guidance, absolutely. Okay. And their judgment should be given deference.
So in this case, after the second remand, the district court was proceeding to address that when you filed the first writ in docket 83598, which we declined to entertain, saying it was moot because the district court is addressing this. On this third remand, without ever moving the district court, either party, the writ was filed. So how should we even be entertaining this writ? If it was moot before, when you asked the district court to do something here, you didn't ask the district court to do anything and just jumped up here. So I get your concerns with Valdez-Jimenez and how we should fashion things, but I'm concerned that we shouldn't even entertain the writ from a procedural standpoint.
So a couple of answers there. The question is an adequate remedy at law. And so, Your Honor, what you have is an unaverred situation in front of you that, based upon the transcripts and the multiple hearings that you have in front of you, the district court fundamentally believes that it can hold a pretrial defendant based upon putative violations of the EMP program for an indeterminate period of time. Beyond that, Your Honor, if you will allow me, the reason why there is no speedy or adequate or plain remedy here is because we already went in front of the court. These arguments were already presented to the court. The court, rather amazingly, actually held Mr. Johnston without bail under NRS 178.487, which requires a felony conviction, or not a felony conviction, but proof evident and presumption great of a new felony charge, and held him without bail pending the resolution of the evidentiary hearing. So, Your Honor, the question isn't whether or not we've asked the court for this remedy, but the question is how many times do we have to ask the court for the remedy and be denied before the Supreme Court will take jurisdiction of the case?
Well, you asked the district court on a separate occasion based on a separate remand, and the court and we declined to entertain the writ in that scenario, and the court ultimately allowed him to be released back onto house arrest. Now we have a new scenario.
Yes, Your Honor.
So what I'm struggling with is the position that you're taking, which seems to be, well, I don't like what they did last time, so I'm not even going to talk to the district court again. I'm just going to the Supreme Court and see if I can get them to wait.
Actually, you don't. If I may, I'd like to reserve the remainder of my time, but if I can finish answering your question.
Sure.
It's not a matter of not liking the answer. It's of knowing what the answer is going to be before it's even given. And how many times must that question be asked and given the same answer? Here in this case, ultimately, we have the benefit of hindsight, knowing that the answer that we were given before is the identical answer that we were given the second time. And indeed, Your Honor, on your mutinous argument, I'm glad you raised that. Guess who's back in custody again? Not attending these oral arguments and viewing them, but back in custody for electronic monitoring program violations.
Mr. Johnson, I'm guessing.
Indeed. 2 weeks ago, Your Honor, he was placed back in custody by electronic monitoring personnel for the violations of going out to dinner after his normal curfew, and when they did a 10-panel drug screening on him, he came back positive for cocaine. We did a drug panel screening on him 5 days later, and he came back negative. It's the soonest we could get to it, Your Honor. We don't have any other evidence from him as to why he's being held right now. He is still being held without bail by the district court without scheduling a hearing. So, Your Honor, third time's a charm.
Okay, Mr. Claus.
Thank you.
Good afternoon, Justices, and may it please the court. My name is Brianna Lamana, and I represent the respondent, the state of Nevada, in this case. From the state's perspective, this is a case of a defendant who continually violates house arrest rules, but expects that the rules do not apply to him. And should he continue to violate house arrest rules, he should be allowed to walk freely until the district court can litigate, or the parties can litigate this issue in front of the district court. It's my understanding that what the petitioner wants out of this case is for the district court or the house arrest people to place a motion in front of the district court anytime somebody has violated and take time to litigate that motion before a petitioner or a defendant is ever placed back into custody. I think that's problematic for several reasons.
Counsel, isn't there a tension between bringing somebody who is remanded promptly before a magistrate and remanding somebody and waiting 30, 60 days before they ever see a judge? And isn't there a tension there?
There is, Your Honor, and certainly there is a mechanism in place for somebody to be brought promptly in front of a judge. In fact, even in this case, when Mr. Johnston was arrested or remanded back into custody by house arrest the second time, parties were notified right away about the fact that he had been placed back into custody. There wasn't even a letter yet saying as to why he was placed back in custody, but both parties, both the state and Mr. Claus, were informed right away that he was placed back into custody. And in fact, that letter specifically said, that email specifically said, please inform us if you would like this matter placed on calendar. That's the mechanism. We are given notice, and not in every single case does the defense attorney or the state want to place it back on calendar. There are certain cases where a defendant may pick up a new case that isn't immediately placed back on calendar because we're litigating the case down in justice court as to what's going on, whether there's probable cause. And it's ultimately up to the defense attorney and his client as to whether they want it placed back on calendar immediately.
But it's a different situation where there's a new case.
Absolutely.
Under the statute as well. So here we're just talking about violations, not just, but violations of the release. So who bears the burden in that regard about keeping him remanded?
Well, I believe that the court gives the parties notice, and then it's up to the parties to decide what to do from there.
But who bears the burden of supporting that? So he goes in, and then, or the defendant goes into custody, and then what?
Certainly, if there's a hearing, I believe that the state bears the burden of proving up the violations, which includes arguing the house arrest letter, which we did in this case, and then ultimately when an evidentiary, or if an evidentiary hearing is granted, arguing at the time of the evidentiary hearing. And that's exactly what we've done in this case. I do believe the state bears the burden of proving up those allegations, whether that's just through the letter and making the arguments or through an evidentiary hearing. But I certainly believe that notice is given to the parties, and that notice is sufficient for the parties to decide if and when they may place it on calendar.
So my understanding in this particular case, the remand that we're talking about here, he was arrested on a Saturday afternoon. House arrest notifies the general court email, if you will, and then the department assigned to the case reached out to the parties Monday morning at like 9 o'clock to say, this gentleman got picked up. Let me know what you want to do, essentially.
That's correct.
Did anybody respond to that in any fashion, saying, yep, put it on calendar, please, or no?
Nobody did, Your Honor. My understanding is that Mr. Claus responded, but I don't remember the exact wording of the response, that he responded but didn't ask specifically that it was going to be placed on calendar.
I think the response, and Mr. Claus can correct me if I'm wrong, was that he was in trial, so he asked the court to let him know if the court placed it on calendar at that time, which obviously everybody's extremely busy, I get it, but nobody ever moved the court in any fashion that you know of here.
That's correct, Your Honor.
Prior to the writ being filed?
That's correct, Your Honor.
Okay.
And it wasn't until after the writ was filed and when the state moved for a continuance of the trial in January that defense counsel at that point, or the petitioner at that point, petitioned the court and asked the court to release Mr. Johnston. As to the facts of this case, as Mr. Claus indicated, the petitioner is back in custody now for a violation. All of that Mr. Claus has been diligently working on orders in order to try to litigate that issue. But again, we were informed immediately by the court when he was placed into custody, why he was placed into custody, and given the option to place it on calendar. And it still has not been placed on calendar to address that. And I think that the notice is the important part here. There is a process in place. We give notice to defense counsel and the state as to when somebody is placed into custody, and then it's upon the parties to litigate that if they so choose in front of the district court.
In instances in which that occurs, how long does it take in the 8th District to get a hearing on a request made by the defendant to review the violation?
In some departments, it's fairly quick. It really varies from department to department. In some departments, you can get it placed on the next calendar because there's no motion work that is required. However, if a motion needs to be filed, it takes approximately 2 weeks for a motion to be filed, a response to be filed, and for it to be litigated.
So the 8th
argument.
District is not in front of us, but you are on behalf of the state. Is it the state's position that Valdez-Jimenez does not apply to these types of violations?
It is the state's position that Valdez-Jimenez does not apply.
What's the basis for that?
It's the state's position that every defendant gets their Valdez-Jimenez hearing at the beginning of the case, whether that's in justice court.
What language in Valdez is so limiting? What language in Valdez is so limiting to that interpretation?
And Your Honor, the way that I read Valdez-Jimenez, and I understand that you wrote the opinion, so you obviously know the language better than I do, but the way that I read Valdez-Jimenez is that upon the initial arrest, there's 72-hour argumentative hearing where it is for the state's burden to prove by clear and convincing evidence that there is no less restrictive means to protect the community and ensure future court appearances.
So you would agree with Mr. Claus's concern expressed in the first portion of his argument that both the state and do you agree the 8th District conclude that Valdez-Jimenez is interpreted narrowly as you suggest?
Yes, Your Honor, I do believe that it should only apply when a person is initially arrested on a case or when a case goes up through the grand jury or something along those lines.
So is it permissible under the Constitution for a defendant who, like in this case, is charged with committing a violation of electronic monitoring and sits in jail for 2 months?
Your Honor, I think that what is permissible under the Constitution is weighing liberty interest against that of the safety of the community. And I think that that is one of the key things that Valdez-Jimenez stands for.
That may be true, but there's been no finding. All there is an allegation that the guy violated the electronic monitoring, and they picked him up and they put him in jail. Then nothing happens for months in 2 separate instances. Is that permissible?
And nothing happens for months because the petitioner didn't do anything to move the court to do something.
Wouldn't it be at least logical and wise, separate from whether Valdez-Jimenez applies, for the district court, upon receiving notice that a gentleman or a young lady has been remanded to custody on a house arrest violation, to put it on the next calendar as a status check? And make inquiry. Are you going to file a motion? Are the state going to file a motion? I'm not saying the district court should move on its own to remand, But look, we all know that sometimes defense attorneys may not move for a release because maybe the defendant has multiple cases in the system and they're collecting credit while they're in custody on all of them. And until they can address the primary reason for custodial status, maybe they don't want to move for their release on something. But should the court be directed to have an obligation to put it on calendar in some fashion, rather than the court saying, well, I told you about him and now I'm done with my part?
I certainly think it would be beneficial to move it along faster, but I don't know that the court has any requirement to do that under the law as it stands.
So let me ask you though, if there was a remand and nobody did anything, so that notice goes out, how long would the defendant stay there before something happened? So there's no finding by a court. A court has released the defendant on certain conditions. And as Justice Hardesty pointed out, there's been an allegation made. So could be a month, could be 6 months, and then that's it.
That's correct, Your Honor, and certainly that is problematic, but I think the situation we have now is that the 8th Judicial District Court is giving notice to parties, including in this case.
But what militates against a defendant who is rearrested being promptly brought before the court as a notice, like, hey, they've been arrested, here they are, to take control of the case, make sure that the state has adequate reason to support the remand or the arrest? What militates against that position?
And just to be clear, I don't believe the state has anything against it being brought promptly in front of the court. The issue here is that we don't agree that there needs to be a Valdez-Jimenez hearing specifically because a defendant has already been provided that, and we've already found what the least restrictive means are. And in these sorts of cases, that's electronic monitoring, and that's not used in every single case. That's used pretty sparingly, at least in my experience, that a defendant is given electronic monitoring. And if they're unable to abide by the rules of the electronic monitoring program, I don't believe that then entitles them to an entirely new Valdez-Jimenez hearing. Certainly it entitles them to a hearing, but I certainly think a Valdez-Jimenez hearing is separate and apart from that.
So maybe for the benefit of the students, what did the district court find after the first violation when he finally got back in front of the court and he was put back on electronic monitoring?
There was an evidentiary hearing as requested by the petitioner. At that point, neither of the house arrest officers were available. One of them had a prior conflict with the date. The other one actually went into the hospital due to an injury the day before. I represented that to the district court. We had a mini hearing at that point. The petitioner brought an individual who we believed to be, when watching the body-worn camera, we believed that the alleged victim in this case was actually present at the petitioner's residence, which was really his business at that point. When we believed it to be the alleged victim, that was part of the basis for the first hearing and why he was put into custody, because he had a no contact order. She's of similar height, similar statute, looks similar. Even the court found that based on watching the body worn camera, she looked similar to the alleged victim, and it would have been very difficult to determine who she was because she was refusing to give her license at that point. After the petitioner brought the person who was not the alleged victim to the hearing to indicate under oath that she was the person who was present in the body worn camera and that her name was not the alleged victim's name, the court found that that was her concern, the major violation, and that since that was not proven to be true, that she believed he could be placed back on house arrest, and that he was told specifically not to live at his place of business because it was not accessible to house arrest personnel, which is obviously a safety concern and makes it near impossible for them to supervise someone if they can't have access to the residence. So he was placed back on house arrest at that time.
How long had he been in custody from the time he was taken into custody to the time that the judge made that determination that the witness victim was incorrectly identified and sent him back on house arrest?
If I remember correctly, it was approximately a month.
So So I understand, it seems to be that the state's position is that there's no Valdez-Jimenez type prompt hearing required when somebody is surrendered on house arrest, and the defendant has the burden of placing the matter on calendar to get some type of court involvement.
As of right now, I do believe the way that it stands in the notice that we received from the district court, the defendant does have some sort of obligation to place it on calendar if he wants to address his custody status, because he is the person who has violated at that point. Certainly then the burden shifts to the state in order to prove those allegations, given the fact that house arrest, I do believe, is an entity of the court, but certainly house arrest is placing them back in custody, and it's the state's argument that they should remain in custody. I do believe that the burden then shifts to the state. But and the prompt.
So stay with me for a moment.
Absolutely.
Because there's kind of this hybrid type situation has an inherent conflict, right? You're saying the state has the obligation of proving that the violations were committed and therefore he's justifiably back in custody, but you don't have any obligation to put it on calendar to address that.
That's correct, Your Honor. I think that that falls on the defendant, as they're the person who's violated the house arrest rule.
Well, allegedly. That's the allegation.
Correct.
And here we know at least that allegation was found to be not true.
One of the allegations was found to be not true. And another allegation in both of the house arrest violations for this specific defendant was that he was refusing to do UAs, the urinalysis test, the random urinalysis test. And right now, considering the fact that he's back in custody for testing dirty on the urinalysis test, I think we can presume as to why that would be.
Well, I don't know if that's part of this record.
It's not, Your Honor, but petitioner did bring it up, so I just wanted to clarify.
One other point I wanted to ask you about. Justice Herndon appropriately asked Mr. Claus about whether we should entertain this writ, but it seems like, based on your acknowledgement, that there is a narrow reading of Valdez-Jimenez and its application to just arrests and not instances in which a defendant who's under house arrest or electronic monitoring or some other alternative supervision suggests to me that maybe the court should entertain the writ for the purposes, as we do in some cases, of offering instruction and guidance to the district courts about what the rule is here. Do you share that view?
I don't, Your Honor. I believe that there is a plain, speedy, and adequate remedy already in the court system, that there is a system. As I indicated, the narrow reading of Valdez-Jimenez is simply that it doesn't apply when somebody has been found to be appropriate for electronic monitoring, simply because there is no least restrictive, other least restrictive.
But it does seem to be problematic if a person who's been found by the court to not be a risk to the community and to make future appearances under conditions that the court set, and then there is a disputed allegation of a violation. And if the process is that the state has the burden to establish that but doesn't have the burden to set the hearing, that seems like an individual could sit in custody for an extended period of time without any remedy whatsoever, especially someone who, for example, is unrepresented by counsel.
And Your Honor, if I may, I believe that there's a difference between the Valdez-Jimenez hearing and having a speedy hearing of itself. That's the distinction that I want to make. The Valdez-Jimenez, I think, is that least restrictive means, that initial appearance in front of the court in order to determine what is the least restrictive means to ensure future court appearances and protect the community. Whereas this is an individual who has been given that opportunity, has failed at that opportunity, allegedly has failed at that opportunity, and is now needs to be brought before the court. And whether that needs to happen prompter than it is now, I can understand that, but I just want to make that distinction.
Go ahead,
look, I played devil's advocate with Mr. Claus, so I'll do the same with you, right? Whether we call it a Valdez-Jimenez hearing, or maybe we now call it the Johnston hearing, right? I mean, new tenets of law come about just like with other bad acts, and you change the name of the hearing. One of the imports of Valdez-Jimenez wasn't about the attorneys, it was about what does the court need to do. So I think part of what Justice Hardesty was getting at, and I don't need to put words in the gentleman's mouth, is what do we need to direct the court to do? If the parties are going to set for whatever reason, do we need to be directing the court that they've got an obligation in effectively managing their calendar and being fair to litigants to put the case on the calendar so that you can get the parties in and kind of figure out what's what, so to speak.
And as I said, I don't think that having a more prompt hearing is necessarily a bad thing. So if the court feels that it needs to direct the district courts in putting it on calendar more promptly, we just take issues with some of the other things that are suggested by petitioner as to what needs to happen, such as filing a motion before a petitioner ever goes into custody, which I think is an issue when we're looking at flight risk and a danger to the community, which is largely the individuals who are being placed on electronic monitoring.
Okay, counsel, thank you for your arguments. Mr. Claus will add 1.5 minutes to your time on rebuttal.
Thank you, Your Honor. May it please the court, you are following right down the right path. When this first set of hearings were conducted in October, not only did house arrest not send any individuals to put forward their point of view, the state has created a situation where Valdez-Jimenez clearly indicates that there must be a prompt individualized determination before someone is released on bail right after they're arrested. And Anaya v. State from the state itself says that when someone is picked up on a probation violation, they're entitled to both probable cause determination and an individualized hearing as to whether or not the facts put forward by parole and probation can in fact be supported. But the state's in the middle argument is don't look at Valdez-Jimenez, even though by its language it can apply to this situation. And let's be clear about what happened in the October hearing. Not only did house arrest personnel not show up after the hearing being continued precisely for them to show up, but then we produced body camera and witnesses to indicate that the EMP report was impalpably false. The only disagreement that I had with the judge was whether it was maliciously false or whether it was grossly negligently false. The individual was found in Mr. Derek Johnston's bed. Ms. Manicomb identified herself by her driver's license number by reciting it to officers off the top of her head. Her vital statistics show that she is somewhere between 7 and 9 inches shorter than Chelsea Sellinger. There is no reasonable investigation that these officers could have conducted to come to the conclusion that Ms. Sellinger was sleeping in his bed. They simply didn't. And the only question is whether they wanted to maliciously get at him or they just forgot to look up and scope Ms. Sellinger's identifiers. Moreover, this purported violation of failing to take a drug test. Your Honor, the first time it happened, he was already in handcuffs and they said, oh, by the way, we've already decided to arrest you. We think it's a good idea. Would you be willing to take a drug test? And he says, rather reasonably, are you gonna not take me to jail? No, well then I'm not gonna take it. They offer him the same choice at the second violation that happens here. We'd like you to take a drug test. And he says to them at CCDC, are you going to let me go? And they say no. And he said, well, then no, I'm not going to give you a drug test because you've already made a determination that you're going to take me into custody and that I violated the terms of my electronic monitoring prohibitions.
Just out of curiosity, what is the under your experience, the general practice of the district courts in this regard? Do some courts put it on calendar when they get that notice from house arrest? Do all the courts just wait for somebody to do anything?
No courts put it on calendar. In fact, I put that in my brief, Your Honor. In terms of the mootness argument here, I gave you several cases. Case C-353746, where the defendant was taken into custody for a case that predated his house arrest and stayed in custody for 2 months until someone filed a motion and he was immediately released. In case number C-358402, he was taken into custody and even the court didn't know why until a month later. This is rampant through the judicial district court, and they're handling it completely differently, and they're acting as though NRS 178-4851 doesn't exist. And coupled with Valdez-Jimenez, we reach a common sense Easy conclusion. Valdez Jimenez says you need a prompt individualized determination if somebody's been arrested and they're not being released. Now we've got a problem because there's no probable cause determination here. The notices that are being given, and you have 2 of them, these are courtesy administrative notices that are given only to the court. They're not even sent to the defense counsel directly. They're not filed with the court, and if the court sends them to the wrong person via email, which no one in this court I think would accept as legal service or notice that something is occurring, they simply get shuffled off. They get lost. And
Counsel, just briefly, as a practical matter, you got notice from the court that a client was in custody. How long would it take you to get that matter on calendar?
Your Honor, if I requested it, it would be relatively quickly, but under the rubric under which the 8th Judicial District Court is operating, the difficulty is the burden lies with me. So instead of the state having to even produce the EMP personnel to verify what they do, which they would have to do in a probation violation hearing, you yourself, Your Honor, if I may finish the thought.
Don't ask me, you got to ask the chief.
May I please finish the thought, Your Honor? In a probation violation hearing, if the officers failed to show up 2 times for a hearing and just thumbed their nose at the court and failed to produce any other evidence or produce any other witnesses, what would the court do there? Would the court continue to say, you know what, I'm going to find violations have occurred here absent the testimony? Or would the court say, I'm going to dismiss this. If it's a real violation, bring it back to me with a live body to tell me why it happened and how? If I may just make one final point, please, Chief Justice.
I think you're concluded.
Very well.
All right. I thank you both for your arguments here today. I'd like to indulge your patience and ask you to introduce yourself to the students and speak a little bit about where you went to school and what got you into the practice of law. So, counsel.
Hi everyone, my name is Brianna Milana. I went to school, a law school at Lloyd. I am not a Vegas local because I was technically born in Utah, but I've lived here since 6 weeks, so I've always called Vegas home. I love practicing in this community. After law school, before I started at the district attorney's office, I actually worked as a law clerk for then judge, but now Justice Kish. And that was an absolutely amazing experience. This is actually my first oral argument in front of the Supreme Court.
Mr. Claus.
Good afternoon. My name is Augustus Claus, and I didn't know I was going to be an attorney. Didn't even really want to be. I can't say I really grew up anywhere. Born in California. I spent some time in Oregon, going to law school, traveling back and forth from one person to another.